Welcome to the latest Evershed Sutherland Legal Insights podcast.
Hello everybody, this is Naeema Choudry. I'm joined today with my colleague Suzanne Caveney, and we're going to be talking about the new Worker Protection Amendment of Equality Act 2010 Act 2023, which is due to come into force very soon. Suzanne, could you tell our listeners what the changes are with this legislation and when it is actually coming into force?
Of course, and hi everybody. Yeah, these changes are really quite significant. I think a lot more significant than a lot of employers have realised so far. So the legislative changes themselves are due to come into force on the 26th of October this year. So not a lot of time to get your house in order. Many of our listeners will be familiar with the concept of harassment, will be familiar with the concept of reasonable steps as a defence to a harassment claim. The significance of these changes, however, comes with the fact that this is the introduction of the first proactive duty to actually prevent harassment in the first place. So that is a duty to take active steps to prevent harassment in the workplace. It's the first time that we've seen a duty like this, and it means that employers are going to have to take steps in anticipation of preventing harassment rather than relying on reasonable steps as a defence to a tribunal claim. So really quite significant changes coming down the line.
Thanks, Suzanne. So, as you've mentioned, we've all been familiar with the reasonable steps defence in terms of a defence to a claim for discrimination. And in my experience, that's quite a high hurdle for employers to pass. And in fact, in all the years that I have been doing equality work, I haven't come across an employer that has successfully implemented that defence in an employment tribunal claim. So it seems to me that if it's a reasonable steps defence, this is going to be quite far-reaching for employers. Can you just talk us through some of the steps that an employer might have to take in order to satisfy this hurdle?
Absolutely, and I completely agree with you. My experience is exactly the same. It's an incredibly difficult defence to run. So this is a high bar. What we are talking to a lot of clients about at the moment are taking those active steps in the form of really understanding what the risk profile looks like for them, looking at specific circumstances like late working, lone working, remote working, social events, and starting to undertake risk assessments around what that sexual harassment risk might look like in those specific circumstances. Because unless you are taking steps to understand where the risk might arise, you're not in a position to prevent that risk from arising in the first place. The key point with steps like risk assessments, however, is making sure that they're constantly evaluated. That you're then looking at those risks and taking active steps to overcome them. So let's think about something like a social event as an example of where sexual harassment might be a risk. Are you really looking at that? Are you thinking about that in anticipation of those events happening? And what steps can you put in place to prevent that risk? Things like limiting the amount of alcohol that might be available, for example. Training is going to form a huge part of a reasonable steps agenda. So we recommend taking steps such as role-specific training. Are your managers equipped to understand what their obligations are, understanding what the consequences are of not intervening? So for them personally, but also for their employer, making sure that those managers are really equipped with the tools to challenge behaviour in the moment, if that is appropriate, or at least to challenge behaviour after the fact, if that's the most appropriate response. Because unless we have a culture where this behaviour is called out, you're not going to be in a position to then demonstrate that reasonable steps have been taken. So there are a number of steps that can be put in place, that should be put in place right now, really in anticipation of this duty coming into force. Because as you say, the bar is set really quite high. So simply rolling out D&I training as a tick box exercise once a year for everyone just isn't going to be enough, in my opinion.
No, and I think, as you say, you'll have to do training that is tailored to different aspects of your working workforce, because the training that you might want to give to the board may be very different to the training that you give to your managers, to the training that you might give to other employees that don't have line management responsibility. And I suppose what you're going to have to also do is not only um, do that training, but you're going to have to keep an eye on your onboarding to look at your people who are coming and leaving, to make sure actually that people are constantly being updated. Because if you've got a transition workforce, the training that you might have done 6 months ago, you might actually not be capturing the whole of your population. So you might need to have something on your onboarding program to make sure that everybody is captured. And also, you're going to have to demonstrate, I would say, that not only have they had the training, but people have understood it and what type of training you have done. So you're probably going to have to keep records of the packs of the training, who delivered the training, when that training took place. I know that when, you know, you're defending an employer in the employment tribunal, it's very difficult to get details of who's had training and when, but this is going to be even more widespread, isn't it? Because with it being a proactive duty, you're going to be having to constantly update it.
Absolutely. And, more often than not, when I'm asking clients in defending harassment claims what their reasonable steps look like, they're referring to one-off diversity and inclusion training that an individual might have had months, even years previously and never again, and maybe online training that they're simply required to click through. And, do they have half an eye on their emails whilst they're doing that? Have they really understood and taken on board what it means on a practical level for them personally, for their employer, and to really evaluate the effectiveness of that training? And as you say, making sure that everyone is caught. It's difficult enough to defend these claims on that basis, but we need to remember now, actually tribunals are going to be duty bound when a harassment claim is successful. They're going to be duty bound to take into account whether the reasonable steps have been taken actively and proactively, and there are financial consequences now, an uplift of up to 25% in compensation if they haven't been doing that. So many reasons why this is significant, so many reasons why this is important. And as you say, training is going to play a key part, but it has to be more than what we've traditionally seen, I think, to this point.
And I think one of the other slightly surprising aspects of this legislation is that although the Equality Act doesn't cover third party harassment per se, the Equality and Human Rights Commission has updated its technical guidance on sexual harassment in response to this legislation. And that has the technical guidance now says, or will be saying, because we've not had the final version yet, that the duty to prevent sexual harassment applies to harassment by third parties. So arguably, you're going to have some form of dialogue with your, suppliers, your contractors, to see what their policies are. To maybe you may want to audit to make sure that they are training their people as well. And if you're going to have third parties and contractors on your businesses, you may actually want to mandate that they also undertake your sexual harassment training, so that you can make sure that you have taken reasonable steps to prevent harassment from occurring.
Yeah, exactly. And there are so many reasons why we might want to do that. As you've already pointed out, it's a little bit unclear the extent to which the legislation that's going to be coming into force in October actually mandates that. not quite so clear in the legislation. The Equality and Human Rights Commission is suggesting that their interpretation certainly is that that should be happening. We also know that the new Labour government has indicated an intention to make it mandatory to the extent that it isn't already. But if we just think about the general DE&I implications of this duty anyway, it's in everyone's interest, isn't it, to make sure that really everyone that an individual is coming into contact with throughout their working day understands how important this is, understands what an employer's expectations are about the standards of behaviour whilst interacting with their employees. Easier said than done, perhaps in some workplaces than others. But to your point, Naeema, it's going to be really important to make sure that those contractual relationships are clear, those standards, expected standards of behaviour are absolutely clear, and that there are consequences for getting that wrong. That's going to
Well,
be a key part of it as well.
yeah, and I think certain industries are going to be perhaps more impacted than others, particularly, for example, in the retail sector where there's a lot of customer focus,
Yeah.
where you're not necessarily going to be able to control the actions of the customer, but what you can do is show your support to your employees and make it clear that this is not something that you will tolerate. So, you often see signs where organizations have made it clear that they won't tolerate the harassment of their staff or abuse towards their staff. It may involve you having to consider not allowing customers to, interact with your employees, which can be quite difficult decisions. And I just wanted to just sort of move away a little bit from that aspect and talk a little bit about, the consequences. You mentioned that um, there is a 25% uplift in a case where a tribunal finds that sexual harassment has taken place and the employer hasn't taken reasonable steps to prevent it. But can the Equality and Human Rights Commission also do something about it?
Yeah, absolutely. They're going to be very interested in the judgments that are coming from the tribunal. We've all had, well, I've certainly had experience of clients who have lost these sorts of claims even before this duty has come into force. And due to the nature of the compensation that's been awarded or the judgment that's come through from the Employment Tribunal, the Equality and Human Rights Commission is then taking an interest in that employer and thinking, well, hang on a minute, what's going on here? And they have the power to come into the employer, to look at what the processes are, to really satisfy themselves. Well, hang on, is this something that this employer isn't taking seriously? What are they doing? Is this a one-off judgment, or is this a more institutional, systemic problem that we need to be taking an interest in? And that's not something that any employer is going to want to have to deal with. We don't want the Equalities and Human Rights Commission at the door asking to see what the training program looks like, asking to see what the policies are, speaking to individual employees and managers potentially about their understanding of the duty. So as we've said, so many reasons, financial and otherwise, and from a general DE&I strategy perspective, not least because we want to stay on the right side of the Equality and Human Rights Commission. Absolutely.
But I suppose this is also about, there's a law, but it's also about a business's brand and reputation, isn't it? And
Yeah.
it seems to me that this is going to involve a big cultural change. So, with the fact that it's got to be proactive, you know, you're going to have to look at your culture, the types of things that you are doing, and sort of, you can't look at it in isolation as a piece of legislation that you've got to comply with. It's got to form part of your wider DE&I strategy,
Yeah.
and sort of demonstrate to others and to your employees the type of employer that you want to be, and what your stance is.
And that's higher on the agenda now than it has ever been. We always say, I know, Naeema, you and I provide training on this very frequently, and we always say if employers are becoming too technical about this and splitting hairs, for example, between what is technically sexual harassment versus general harassment, then that's looking at it through the wrong end of the telescope. There are so many advantages to getting this right from a cultural perspective, being a great place to work. If you have customers, for example, they are going to be looking at your reputation in this space as they are in the general DE&I space. But equally, there are the same consequences on the flip side of the coin for getting this wrong, reputationally getting it wrong, as well as financially and legally. It's not just about the tribunal judgments, which are significant in themselves, but it's also, the court of public opinion. How are employers going to fare with customers, with consumers, or with prospective employees who might be looking at you as a place to work if you're splashed over the headlines because you haven't been getting this stuff right? So I've said it more than once, but it's so important. There are so many reasons why this is important.
So really, in terms of next steps for employers, I would say that really an employer needs to be looking at action plans in the first place. So looking at the high risk areas and putting together an action plan of what they're going to do and when they're going to do it, because this will not only look at the highest risk areas, but you may need to consider your policies, you may need to look at your contracts of employment. We've talked quite a lot about training, but also you're going to have to look at your culture, get your board engaged and on side, and also you may want to seek feedback from your employees about their experiences. You may actually also want to update your whistleblowing policies because people sometimes want to report these things on an anonymous basis. And also, if you recognize a trade union or you have some form of employee forum, it's always good to get them on board and engaged on the process.
Yeah, and that dialogue is so important. It sometimes feels a little bit scary, a little bit counterintuitive to be asking employees about what their experience is. But one of the main drivers for this amendment to the legislation is the fact that despite harassment being unlawful for years, its statistics show it is still happening. And just because employers are not receiving grievances, just because they're not receiving employment tribunal claims, doesn't mean it's not happening. So as intimidating as it might be thinking about, lifting that rock and seeing what's underneath it, unless you're prepared to do that and have that dialogue with employee representatives or the employee population as a whole, if you don't know what the problem is, how are you going to fix it? Which is also why it's so important that this is driven from the top. You've mentioned board engagement a couple of times. That's really important because they need to understand the significance of this change of the legislation. They also need to understand the significance of that employee engagement so that, as I've said, so we can fix the problem and really understand what it is.
Thank you. And I'm just conscious on a final note that we now have a Labour government. Is there any suggestion that this legislation will change in the near future?
Very possibly. So we've already mentioned the concept of third-party harassment and the fact that as the legislation currently stands, it's a little bit unclear about the extent to which that's caught. Labour have made it very clear that they intend to make sure that that is mandatory to the extent that it isn't already. They've also suggested that they're going to reintroduce the concept of all reasonable steps. So at the moment, the way that the legislation is going to work from the 26th of October, it's reasonable steps. The suggestion that it was going to be all reasonable steps was actually dropped during the consultation. Labour are suggesting they're going to reintroduce that. Now, whether that will make a difference in practice, I think remains to be seen. But what it does do is demonstrate the direction of travel.
It's a higher burden, isn't it?
Yeah, it's going to be a higher burden, and certainly the introduction of the new government is not going to dilute this duty. If anything, it's going to get more difficult to comply with. So certainly not something that we can think, well, I know it's coming to force, but we've got a new government, so it all might change. It might, but it will become more of a duty, not less of a duty, that's for sure.
Thank you, Suzanne. Well, I hope that gives our listeners some action plans for next steps. But if anybody does need any more detailed assistance, then please do reach out to us. Thank you.
Thank you for listening to the Evershed Sutherland Legal Insights podcast.